5, Mr. Johnson is charged with aggravated assault with a deadly weapon, and Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case.
Jonah's mom, correct?
Yes.
And the original bond back in September was $150,000. Wasn't that correct?
Yes, sir.
And what went wrong? What was the problem there?
The ankle monitor. We thought it was broken, which that was, we called Johnny, and Johnny told us to come in, which we had been talking with Johnny for 2 weeks. But like I say, Johnny said come in, and something was going on with the monitor. And we also was the payment behind.
So the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located. Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk. Was Jonah working when all this happened?
Yes, sir.
Where was he working? He lived with you. Is he a flight risk?
No, sir. He's not.
Are you worried about him taking off or running off?
No, sir, I'm not.
And you wouldn't waste your money if you...
No, sir.
What would be reasonable?
At least $100,000. We had talked on that.
Well, it was $150,000 back then.
Yes, sir.
So it's not really realistic that that the court would drop to $100,000 now.
Mm-hmm.
But to go back to the $150,000, would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually seen it?
Yes, ma'am.
Are you aware that in the last 5 years, your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Mr. Pullman?
Judge, one of the items of evidence that I plan on introducing was the video from the shootout, but it sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to. Well,
first of all, I'm going to take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other case that we had a bond hearing on. Is that correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there's a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at $300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
There is something, Judge. I think that it's at least, if you're going to deny, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of a jail phone call that I've added subtitles to. If I could do that, I'm happy to bring my sponsored witness, but if you'll stipulate to it.
No, I'm going to object to it to relevance.
Bring your witness, please.
Yeah. State calls Captain Michael Pond.
It's about a 5-minute excerpt from a 14-minute and 20.
Well, so it's been altered.
It's been included, yes.
Object to the alteration, yeah.
Judge, what's on here is the original 14-minute long video, as well as by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States 1, with both, will be admitted.
Then there's a transcription. I object to that as hearsay.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
How is it hearsay?
What they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, Judge, it's
I
just,
obviously will be able to listen myself and your objection's overruled. It's admitted.
Commissioner Publisher.
He came back in, he said, like, oh my man, I didn't hear people went crazy for me. Well, no, he said people screaming that shit was real. But a couple days later, first it was cool, we just chill. I want to be chill. I wanted 5 years. But they do I put like 2.5 on that bitch. Oh, come on, my brother, thank you. I still bank time, get fed. I'm gonna have some bank time. Sorry, got 5 months bank time right now. You mean that 5 months, bitch? And but it was 5 months I did, boy, this shit look like, you know, that's when I really kind of been flying by. And it is like, once you get in, just want to flying by. Sure. This shit, very bitch, this shit, so man, this is man in the mother, this shit, bird, bitch. Push gonna come to shove, some shit gonna happen.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason is because it sounds like you were working, your parents have the issues. I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right, you can go back with the bailiff.
Jonah Ray Johnson appeared in court seeking a reduction of his $300,000 bond for an aggravated assault with a deadly weapon charge stemming from a violent apartment complex shootout. His mother testified that he lived at home, had steady employment before his arrest, and argued that previous bond issues resulted from misunderstandings over GPS monitoring payments, not because he intended to flee. She asked the judge to restore his original $150,000 bond, promising the family would ensure full compliance with all bond conditions. The prosecution strongly opposed the request, emphasizing Johnson's extensive criminal history, including 9 arrests within the last 5 years, involving weapons, drugs, evading arrest, and vehicle-related offenses.